Ladies and gentlemen, welcome to Vigilance September 2023. On behalf of Italian Exhibition Group, I thank you all for being here and welcome in beautiful Vicenza and Vicenzoro. Vicenzoro in 2023 reached the all-time record because we actually got to a dimension that we never had in almost 70 years in a history. So thank you. Next year we actually celebrating the 70th history. I think we are the oldest B2B jury show in the world at the moment. So good things. But unfortunately, we're gonna remember this 2023 not for this wonderful record, but because our president Lorenzo Cagnoni passed away last week. That's really sad. So let me just take in, few words for remembering him. That was, like our leader, our guidance, our coach, our everything. And as President Mr. Cagnoni was always saying, the reason why we reached this size is not because, we only have more exhibitors down here, not just because we have more visitors visiting us. Is more about the fact that we are bringing here, the authority in jury. More about the fact we are bringing here content, more about the fact that we are bringing here all the opinion leaders, the ideas, the discussion of the hot topics, the discussion about the standards, what we have to do on sustainability, for instance, and you're all involved in here. And we don't pretend to be the authority. We want to be the open platform to host here the authorities, the opinion leaders, they are you. So we don't pretend as Italian Exhibition Group to be the authority in jury. We just serving you, serving the industry to making sure that here we can become all together the appointment, the reference point for the industry. This is what we do. This is what we do, and certainly the authority, especially in sustainability, is Cibjo. So thanks a lot to Cibjo and to Mr. Gaetano Cavalieri to bring here so much about the thinking, the considerations, the reflection on what we should do in the next years. So thank you so much for contributing to the high all-time record of Vicenzoro, because at the end are you making these big results, and we are so blessed and so pleased to support you in whenever we can do. Just as a platform, just serving you and the industry. Thank you so much.
Thank you very much indeed, Dr. Carniello, and thank you very much to all of you for being here with us. Let me thank our speakers, our moderator, Lisa Koenigsberg, Sara Yood from the Jury Vigilance Committee in New York, and the expert that being as an act of courtesy, they went from Milano to New York and then back to Vicenza just in order to align all of them. Thank you very much. I would like to express my deep condolences to Italian Exhibition Group for the loss of President Cagnoni. He has been a great man, and he still is a great man, even though physically he's not with us, unfortunately. But to us, all of us, has been an honor, a pleasure, and a joy working with him for several years. Thank you very much. I give the floor to Lisa, that she is driving this wonderful event. Thank you very much.
Okay, is this live? Can you hear me? Fine? Okay. So good morning, everybody. First of all, it's a pleasure to be here. Second of all, for those of you in the room, please know that you are being joined by others who are watching this via live stream. Cibjo is, and through Vicenza Oro, is streaming this, and so Initiatives in Art and Culture, which is the organization I founded, is doing so as well. We strive to have a participatory environment, so, but also because of the exigencies of time, I'm going to skip some of the introductory material and try to jump in fairly quickly. And for those of you that have comments to make or questions to ask, don't hold back. We invite you to join the conversation. So I'm going to just quickly introduce the, I guess I'm the so-called black sheep of the group, despite wearing white, because I'm the only one not in Navy. And at the far end is Sara Yood from Jewelers Vigilance Committee, and a colleague from the States. And sitting between the two of us are Erika Andreotti, who joined Studio Torta after working in a biomedical company. Now, both of these women are distinguished attorneys with respect to intellectual property. The second one is her colleague Chiara Luzzotti, also from Studio Torta. And one of the things to mention is that they are counsel for Roberto Queen, but at the same time represent other clients as well. Because one of the things we want to bring into the conversation is something of a bit of a European perspective, as opposed to simply the perspective of one particular client. So they'll draw upon their knowledge broadly writ as well as the specifics. And one of the things that is known is that infringement of intellectual property is an international threat. In 2019, it's estimated that 7.1% of watches and jewelry imported to Italy were, in fact, infringements on intellectual property. They were, whatever term one wants to use, fake, fraudulent, etc. And intellectual property, just to make sure that we're all on the same page, is defined in the Cibjo Commission report as a concept that refers to products of the intellect, essentially covering the ideas that come out of the human brain. Intellectual property laws protect those ideas, inventions, and creativity for their creators. And I encourage you all to reference the Cibjo report from the Ethics Commission. Sara was a co-author of that report, and it will frame some of what we discussed today. Now, this is the second part of a 3 or 4 part series, and one of the things that I think, as we were preparing, became evident is that there are various perspectives represented, but there are international issues, there are also issues of size. But in order to set the footing, I thought what would be helpful is to have the perspectives of the various perspectives on the sort of building blocks of intellectual property. So, and to define what your perception is of relative protection or strength. So, I guess we would start with copyright. And I don't know, Sara, if you want to begin or, okay.
Sure. Hi. Good morning. Buongiorno. My name is Sara Yood. I am Deputy General Counsel at the Jewelers Vigilance Committee in New York. We are a trade association over 100 years old that helps the jewelry industry focus on legal compliance and ethics. And I have been warned to speak slowly for the translator, and I will do my best to do so. But when we talk about copyright, copyright protects the expression of ideas, not the ideas themselves, but the expression of it. So things like drawings, art, sculpture, music, literature are all protected under copyright law. And copyright itself, actually, the concept is hundreds of years old. It has been around in various laws, constitutions, the Statute of Anne, and what it essentially does is protects your artistic expression. So when we're talking about it in the context of the jewelry industry, it can protect jewelry designs that are original. So are you going to be able to get copyright protection for your diamond halo ring? You are not. But are you going to be able to get copyright protection for an original design? Possibly yes. In the United States, it's actually quite easy to apply to register a copyright, and it costs $65 to file that application. And copyright protection can last a pretty long time. It's the life of the last living author plus another 70 years. So it's quite long protection, but it's not necessarily the strongest protection that you can get. So that's the American perspective on copyright.
So let me turn to the two of you, and whichever would prefer to answer first, please. We'd love your perspective.
Okay, about copyright. In Europe is more difficult to obtain the same protection. For example, at least in Italy, we have another kind of approach about copyright. For example, here you obtain the copyright protection, so you have not to find anything. So the right is born when you create your work. But the problem is that you need to satisfy two conditions. One is the creative character, and the other one is the artistic value. So the creative character is easy to demonstrate because you have to demonstrate that you are the author of the design. The difficulty is, of course, about the artistic value, because the artistic value is recognized by courts only if you demonstrate that in the field your product has been recognized as a work of art. So you have to demonstrate that you are on magazine, and not only like advertising, but you have to demonstrate that you are recognized as an artistic work. So, for example, you have to demonstrate that museum wants your product to be exposed. So, in that sense, here in Italy is really difficult to obtain a protection on design, for example, in jewelry sector, because you have to demonstrate after a long use that your product has been considered by the public as an art, a piece of art. So it's very difficult. It's easy to obtain, so you have not to do anything to obtain it, but the difficulty is to the judge to recognize it. So I think that it could be a good point after a long use of the product. So if your product is young and you have put on the market the jewel last year, so it's not possible here to obtain a copyright protection, of course. So this is the main difference.
Would you like to add?
Yeah, according to our experience in some countries, copyright works quite well. For example, in China, we have several times registered the copyright of objects, of products like jewelry. This instrument is good, for example, to block counterfeiting on the web, on social media, on marketplaces. So copyright is strange IP rights because, as my colleague said, in Italy is a weak tool. But in other countries may be a good tool to fight counterfeiting. So the strategy depends on the markets, depends on the legislation, depends on the court law, and so on. So the approach must be on a case-to-case basis, of course.
Okay, so Sara, next on the list would be trademarks.
Sure. So a trademark protects your brand identity. So that can be your brand name, your logo, a slogan, anything that serves to identify the source of your goods. So if you think about the best example we have of this is Coca-Cola, right? So we have the name Coca-Cola, that is a trademark. We have the logo in that red script, that is a trademark. We have the red color of the script, that is a trademark. And we have the shape of the Coca-Cola bottle, that is a trademark. All four of those things serve to identify the source of the goods, the person or the company who created those goods. And so any one of those types of things can serve as a trademark. So good, fun examples of that include the blue color of the Tiffany box is a registered trademark. The color itself, not just the shape of the box or the name Tiffany and Company, which of course are, also trademarks, but the specific color, no other brand can use that color to sell jewelry. But even things like smells or music can serve to identify as a trademark. One interesting point in the jewelry industry is that, as Erica was saying, in Italy, with copyright, it has to be known for artistic value. In the United States, some jewelry designs can achieve trademark status. So the design itself serves to identify as the source of goods. So a great example of that, I think, is the Cartier Love bracelet. They have copyright protection in the United States, but they also have trademark protection for that bracelet because it is so visually identifiable as from Cartier that they have been able to achieve a trademark registration as well.
Thoughts from your perspective?
Yes, Italian and European perspective is similar in a certain point, under certain point, and also different. What I mean, the Italian and European legislation consented to register logos, words, of course, images, colors, letters, sounds, and music, and so on. But alternative trademarks such as colors, pure colors, especially pure colors, are really, really difficult to obtain because the approach of Italian and European offices is really strict. So if you want to try to obtain registration of a pure color, like Tiffany, for example, you can try, but probably you succeed only if you prove that your use is extremely, extremely widespread. So you have to demonstrate that the public recognize that color as coming from your company, your firm. Of course, everyone when see the light blue thinks about Tiffany, of course, but this means that Tiffany has advertised, has used this color to countersign its jewelry and the Maison in general for a long time with efforts in terms of advertising investments and campaigns and so on. Probably the US office, US trademark office, is a bit less strict than European and Italian trademark office. But you can try. The legislation gives you this possibility. Also, for the shape, it's difficult for a European company to obtain protection of a shape as a trademark. It is not impossible, but it is difficult because often the office responds that the shape is common for the market, or is a shape imposed by the product itself. So if you can prove a secondary meaning, so very large use advertising of that shape, you have a chance. Otherwise, the chance is quite low. This is the reason why in Italian European companies tends to protect the shape of a jewelry of another product by design, registered design. So, Erika, if you want to spend some words about this point.
Also because, again, like before I said, if the product is young, it's difficult to demonstrate that a long use as produced in the public said message of distinctiveness, so of origin. So this is the real difficult. So the best way to start with protection is to file a design. Of course, because designs last here in Europe and Italy for 25 years. So you have time then send in the product and with your activity on promoting the product and so on. So for example, Tiffany with the colors and the communication, you have to, you can then work on the construction of what you want to get after. So for example, a trademark, a three-dimensional trademark or a trademark on a color and so on. So you have time to do that. Meanwhile, you are protected by the filing of the design. So I think that this is the approach that we use normally with clients working on shapes. So when we have to protect aesthetic aspects of a product, we start normally with design filing.
So just a follow-up question. Would that also, for example, extend to trademarks themselves and, for example, positioning of motifs and letters? Or is that kind of creation, if you will, different? Or is it as stringent all the way along the line?
It depends, obviously, on the product, but you can file also design on the position, because we can use, for example, dotted lines to exclude protection from the design. So you can represent the product with only some parts in online. with lines, and the other one you can disclaim. So you can use your images to define the scope of protection. So it's common also to use for some like that.
Sara, would there be an analog to that in the States?
So not quite. In the US, we don't have a specific protection mechanism for design in the same way that they have in Italy and in the EU. We do have two different types of patent protection. So a utility patent, which protects inventions and scientific inventions mostly. But in the jewelry industry, applications would include, like if you invented a new kind of clasp for a necklace, that would be something that would be protected under a utility patent. There are also design patents that are available for use, and they are certainly being used in the jewelry industry. However, their protection in the US is shorter than in Italy, and also it is much more expensive to file for them than it is in Europe. So it can cost thousands and thousands of dollars to apply for and obtain a design patent, and you can only apply for one design at a time, whereas I found out in our call that in Italy you can apply for multiple designs at once for design protection.
Yeah. In Italy, but also in Europe, the European approach is the best one for us because it's not so expensive. First of all, you have no examination. So you file the design is not examined, and you have the grant in a couple of days. So you have immediately a right granted. Obviously, this means that if you have to enforce it before the court, you probably have to be sure that your design is valid, so you have to spend money. But the money is spent only if needed. So you can get the protection immediately. You can file multiple design in a single application. This means that the only condition is that they belong to the same Locarno class. So, for example, in jewelry sector, we can file all the collection, the new collection of the year. And you can file bracelet, necklace, and so on. You can file also some parts which will be iconic, no? So a single part of the jewel that is reproduced in all the collection. So you can play with the fact that you have the possibility of filing many designs. You have no limits. You can file what you want. You have a tax for each design, more than one, but is less expensive with respect to the US application. I think that the other aspect is that the scope of protection of a registered design is also extended to similar products. And this is not, for example, true for copyright here in Italy. So copyright here in Italy allows you to act against infringers which copy your product, mainly. But with the registered design, you can act also against designs, so other products, which produce in an informed user the same overall impression. This is the definition of the law. So you can act not only against the copy of your product, but also against products which are similar to yours, and copy the main aspects of your product. It's not necessary to be identical. This is a strong measure because you can use it really also against your competitor, which is not copying you exactly, but want to be similar. And so it's a strong right in my view.
Could you perhaps give us a specific example of such a thing?
For example, you can protect, I can give the bottle. For example, we spoke about the Coca-Cola bottle. You can also, for example, file a design on some parts of the bottle. So only the part, the upper part, only the closure, only the bottom part. And then if another company copies that part that you have copies or makes something similar to yours, is inside infringing your scope of protection of the design, registered design. So we can play with parts of the design, for example. So with the hearings, you can protect only the central part, and the other parts can be represented in dotted lines. So you can put on other parts, other pending parts, but you cannot copy the central one. So we have measure to play. So
if you're an American brand listening to this and thinking, wow, it seems like it's so much easier in Europe to get protection for my designs. Yes, keep going. That is correct. And especially if you're an American brand and you are selling in Europe, your IP strategy might be currently very American focused, and you may want to shift resources into prioritizing filing for design protection in the EU, because that can be very useful to you moving forward.
Yes, I think that this is one of the work we do with the company. So when we work with the company, we strictly work with them, because we have to understand which are the countries where they want the protection. So if they want the protection in, for example, also United States or China, we can change the approach, of course. If there it's easy to obtain a copyright, okay, we can go with them. And so in China and so on. So we start from Europe, but it's better to know which is the intention of the company, which is the aim of the protection, because we have to move quickly. For example, we have also to face the fact that if the company has already shown the product, some countries cannot be again protected, because, for example, in China you have not the grace period, so you cannot show your product and then file a design. While in Italy, in Europe, and also in United States and many other countries, you can show the product and then file a design application. You have a time of 1 year, for example. In other countries, it's 6 months. But, for example, China has not. So if you want the protection in China, we have to start before with the design application. China has, again, a duration which is less, like in United States, it's 15 years. So copyright is very useful, of course.
And when Erica says show, she means display, but also advertise, or even just showing it in your showroom to someone is showing it. It's like, you think of it like publication. If it's public or you put it on Instagram, that is enough to knock it out of consideration in China.
Yeah, and in that case, other instruments can support, so like copyright in China, for example, and in certain cases also trademarks, figurative or three-dimensional trademarks. So the strategy may take into consideration the local legislation, the local approach to IP. I just want to add that the design registration is really helpful to enforce the design rights, the IP rights on your product, also online, to fight against counterfeiting online, because you have a certificate in a short time, and you can upload this right to the platform, or for example, Amazon, Alibaba, etc. And then you can also use the registered design before customs, because you can show to the customs that you have a protection on that collection, on that model, and they act to block counterfeit goods.
Just a follow-up question, which is, at what point in Italy, for example, do you need to file the designs in order to be protected? Does that have to be before they're seen by anyone? Or do you have any amount of time that provides you a grace period?
In Italy, we have the time, we have this grace period. The problem is that if you want then to extend your protection in other countries. So if you want to protect your design only in Italy or in Europe, you can show it and then file.
One of the things that I'm hearing is sort of variegations internationally. So when you have a client, or Sara, when you are providing advice to a member, do you recommend that they seek separate counsel in other countries, or do you represent them or counsel them to retain the same counsel?
In our case, we can represent here physically, directly, only in Europe and Italy. But we have a sort of network of other colleagues working like that, and like us, in all the jurisdictions. So if we need to file in United States or in China and so on, we can do it. And so the client has to face only the problem with me. So and not to find a good colleague like me in another country. So we define the strategy, and then we manage everything with our network of colleagues. So we are working all together, and I think that's the same also.
I think you'll find in the US that most lawyers are control freaks. And they want to know what you're doing. So if you're going to hire an attorney to help with IP strategy in the US, they will then help you find counsel in other locations, just as you said here, to help. And again, that also depends on your business strategy. If you know you're going to be selling in a country, or if you think you might be opening an account in another country, then you talk to your intellectual property lawyer and you say, okay, I'm going to be, I'm opening an account in Vietnam. Can you help me figure out a good IP strategy for that? When we're talking with members, though, I think the biggest difference is between larger companies and smaller companies, because for larger companies, they have a more significant budget, they have more money to spend on protection, and they have I think a bigger impetus to protect everything. For smaller companies, oftentimes we are advising them to focus on their most popular designs or their most original designs or most creative designs to make sure that those get protected first, because that is what is more likely to be copied and infringed.
Here in Italy, we have a lot of small enterprises. So we normally work with a lot of small companies. So I think that, for example, in our our approach is before evaluating the budget and then finding the best way to protect your product on the basis of your budget. So we can, of course, do a lot if the budget is big, but if we can do also little things, but we can help also small companies to reach the protection of their products.
So one of the things I'm also hearing is that protection or vigilance is, if you will, the need to act is expensive. So what strategies do you employ to avoid infringement and to, if you will, monitor to ensure that your client doesn't face that?
You two are the practicing lawyers.
I think Chiara can help us.
I don't think that there is a way to prevent copies because it's a phenomenon that it is even increasing in these last years. Because besides the real market, you have counterfeiting also online, and it is impossible to prevent. You can fight, and if you have your trademarks, designs, copyright protected, registered, you are stronger and you are more effective in fighting counterfeiting phenomenon. You can prevent probably if the market understands that you are strong, you have strong rights, IP rights, probably they stop in advance, but this is not really true. What you can do is fighting. For example, our experience is that you can activate a web monitoring service that is really helpful to detect counterfeiting on the web. That means on the social network like Instagram, Facebook, TikTok, Snapchat, and also the marketplaces, especially Chinese marketplaces are a big problem for the brands. Alibaba Group, 1688, also platform like Etsy, American, and this monitoring service helps the company to detect replicas or other abuses on the web, and we can help the clients to filing complaints and to take down and remove copies, abuses, ads, listings, and so on. For example, in your sector, in the jewelry sector, the success rate is really high. Often around 90% of success, because the online providers recognize creativity and value on the jewelry object. So we have noticed that in comparison to other sectors, the jewelry sector obtains good results with this kind of activity. Also, custom actions are effective. For example, for one of our clients that is really interested in the Arab countries, Arab markets, we have registered designs and trademarks before the local customs. And in few months, we have obtained 3 blocks of counterfeit goods, and this is a good result. Unfortunately, sometimes it is difficult to understand which is the manufacturer of the jewelry, because we can detect, we can understand who is the seller of the copies, of the replicas, but in many countries there is no obligation to put a hallmark that is the manufacturer mark, like in Italy, for example, that is compulsory. This is this is not a good point for you, for the companies, because we can hit the last link of the chain, but not the importer or even the manufacturer. So in some countries we face these difficulties for the client.
And I think also there are brands who get creative about how they protect themselves. One of our JVC members had not just designs being infringed on Etsy, but the actual photos that they took of their jewelry were being used on Etsy to advertise these copies. And so they filed a takedown notice not based on design protection, but based on infringement of the copyright in their photos. And they were able to get those listings taken down.
Yes, yes.
One of the things, however, that I do hear is that having the resources to monitor the web, to have vigilant counsel, basically puts you, I mean, one of the things we're talking about is international distinction. It seems to me we've addressed some of that, but one of the things I hear that is a common issue is small versus large, if you will. And how do you deal with that with respect to your clients? And is that advice you provide or the strategies to monitor different based on the country?
It's different based on the country, and it's different based on the size. And it's also, I think we also have to create knowledge and culture for emerging brands about intellectual property itself, and about the value in protecting it, and about the return on investing in it. I think lots of young designers maybe feel like, oh my gosh, this is so expensive, and I'd rather spend this money on marketing, or I'd rather spend this money on hiring or other things like that. And it's so vitally important to spend what you can on intellectual property protection, because it is going to pay dividends. It will help you defend what's yours, your design, your perspective, and your creativity. And so that's what I tell, especially smaller brands, younger designers, that the investment in this area will pay off in the future.
I definitely agree. Of course, yeah. It's a matter of the treasure of the designer is the design they produce, of course, and so this is it's very important to understand and to have the culture of the fact that if you show your product on the website, or you with Instagram and so on, and everybody in the world will see it, and so it's probable that someone would copy it if it is really good, as you because you believe in your product, of course. But it could be a problem. Of course, you cannot start with protecting everywhere, but you can start with little steps, of course, starting in that field. But with little steps, you can obtain something, of course.
So one of the things I've heard is that, for example, in the United States, copyright is a more effective tool, whereas in Italy and the EU, it's registration of designs. Are there any other pointed differences that you would say are important to take note of?
Yeah, I think yes. The fact is that we have to consider the different legislation, and this is what we do in the starting program when we define the strategy of protection. So, of course, it can be a good strategy to use the best and the more economic instrument we have at disposal to protect the invention. Of course, we always we also file design registration in the United States. And when we do it, probably we do not for the entire collection, but only with the most iconic one, a jewel for the company and so on, because it's cost. And so, but I think that it can be considered, of course, it depends on the company, the product, so it's not always the same. We can change, and we normally do this work with the company itself.
If you were going to advocate for change that would make a difference within the context that you generally function in, what would that be? So Sara, from a US perspective, or you from a Italian or EU perspective, what modifications would you find most helpful?
So in the United States, we have something new that's happening in copyright, and that is that they have created what they're calling a copyright small claims board. And so they are trying to make it easier to file infringement lawsuits, essentially. Anything that is $30,000 damages or under, you'll be able to file with this small claims board. There's 3 sort of like administrative judges who are going to evaluate these claims and then make decisions about them. And so I think that change that is already coming could be very valuable, especially for smaller, younger designers who are maybe facing litigation, that instead they could file this small claims case in the US. They just created this board and they have issued no decisions yet. So we don't know how it's going to go, but I'm very hopeful that it will help smaller players in the market be able to access remedies that they would not otherwise be able to afford. New things about probably something is changing in EU regulation in designs, but is not definite. So it's not. I think it's not useful now to discuss about little modifications and about the rules. We have to say that in this year, the Unified Patent Court has been started. And so, for example, I am a patent attorney because I'm an engineer. I'm not a lawyer, but for here in Europe, it is a big change, of course. So also in filing, in patent filing strategy and so on. So there is one court giving decision for the entire for the countries adhering to the Unified Patent Court, which is not the same, which are not the same countries of the EU, because not all the countries have ratified, but many countries participate.
So, given, if you will, the exigencies of time, I think we need to draw our session to a close, prefacing that closure with the fact that there will be at least a third part of this conversation that will happen in Jaipur, that will create a more international context, if you will, by including India and other countries. Once again, I'd like to refer you all to the Cibjo Commission report, and I would also like to stress, and perhaps you'd like to echo this, somebody here, the criticality of protecting intellectual property and the challenges that this faces internationally. One of the things that I was reading talked about who suffers, and the list included consumers, lost sales for wholesale and retail firms, lost jobs in the wholesale and retail sectors, losses in government revenue. But that doesn't speak to other intangibles like reputational challenge by having, your ideas taken, etc. So I think the general consensus is that this is a tremendous problem and that we need to work together more effectively to address it. Gaetano, do you want to?
Yes. Thank you very much, and thank you to these wonderful experts. More than a simple speaker, they're really great experts. And thank you, Lisa, for moderating this panel in the way you are doing so professionally. And let me also extend to you the satisfaction that Cibjo has to have this cooperation with initiative in arts and culture. And this is one of the steps that we are going forward in this direction. And by the way, Cibjo and initiative in arts and culture are both happy, and I speak also on your behalf, to have this other wonderful cooperation with Watch and Jury Initiative 2030. But let me go to the issue, because this is an issue that is very close to my personal heart and to the heart of Cibjo as an organization. Cibjo is a worldwide organization representing the entire pipeline of the industry from mine to retail. 47 countries, a good number of commercial members, representing many millions of companies through our membership around the world. And this is an issue that is always on the table. Today is not only on the table, even though it has been under the attention of the Cibjo board of directors and myself and those experts, including the legal counsel, such as Sara and Tiffany, such as Mark Allen in Switzerland, such as Udi Chantal in Israel, and many others, because we are lucky to have so many lawyers, super expert in several countries. But this is an issue that we have already decided that protect the industry and protect those, such as Roberto Coin in this case, but not only him, because there are so many others. We have big brands in our membership, and this happens frequently, to continue and bring this to the attention of the governments. Because this is not an issue that could be and could stop those who want to copy. Those who make copies, they will continue to make copies. We cannot stop. Nobody can. But we have to put in place rules and regulations and the monitoring system through which it will be possible to do that. We have already started the conversation with Sara in order to go forward regarding this specific issue into the United States. We will continue in India, and moreover, we will continue in China, because my personal experience in China since many years, when I was member of the board of the Italian Trade Commission, we had a long issue, and I myself at the time, in that kind of quality, I brought a good number of people making copy in fashion into the court, and for the first time ever, the case was won in China, and I'm talking a few years ago. So let's go forward. We are for the protection of the industry, and moreover, we are for the protection of the consumer, because consumer confidence is going to be protected in the way that the consumer may buy consciously whatever they choose to have. So we are for full disclosure, but we are for protection, but we are for monitoring. We are for honesty, if we may say that, despite the fact that the people will continue, unfortunately, to make crimes or break rules. But we are there to fight, and we will fight, as we have done up to now, with extra strength in order to try to win this battle. Ladies and gentlemen, thank you very much.
Thank you.
Thank you all very much. I look forward to continuing this conversation.